Here. These are option.
And in fact, I have let it be after vacation one for admit.
Lordship, there is an interim
Next week, my lord, in that.
next sometime, Lordship. He'll be here in 10 minutes.
After some time prayer, we cannot refuse.
My
Let him come. After that, we may allow you.
my
Yes.
This is a statutory jail. And next, on last occasion on her name has been offshore.
First date was appointed.
MK Brown.
Pardon, what is the name?
MK Brown, Miss MK Brown.
First date.
Thank you.
May I please, Your Lordship? An appeal by the state minor against the acquittal respondent. And by order dated 6/26, leave has been granted, my lord. Pray, my lord, notice may be issued.
Learned.
Or my lord, the delay has been condoned or not.
Condoned.
That is not record, my lord.
I is there.
I perhaps is because in the, my lord, petition cause list also there is no IA, my lord. Only it is stated by the, my lord, leave granted. Lordship may kindly come to the leave petition, my lord. Leave petition number 25/25, my lord. And see the order date 6/2/2020.
And had also appeared.
Here in the leave petition, perhaps, my lord. That is why perhaps the appeal is directed to register, my lord. If your lordship may kindly, my lord.
That order I have seen, but
Not-
there is no reference to any delay.
Delay, my lord.
What have you stated in your leave petition?
Pending, my just I'll see the
No
record.
reference to any
The
delay
delay-
in your leave petition either. The delay has occurred in filing your IA 25
Yes.
itself.
No,
For IA 25 was allowed,
Yeah,
that
delay-
they ought to have been condoned.
condone, madam. That is-
Now we don't know whether there is any order in an
Yes, ma'am, because it is also.
update.
Well,
Uh, 5 of 2020. Is
that is, I want to check the record, madam. If your lordship may kindly keep it for pending board, just my, I'll just check it.
dash days in.
I'll just verify, my lord, because the appeal has been filed by madam another. I keep it pending, my lord, for some time, my lord, petition. Lost time being, my lord. I'm obliged.
Wait, please, your lordship. This is a statutory appeal against the conviction of 3 years and a fine of 8,000 under section 8 of POCSO, your lordship. Now, your lordship, otherwise, since it's an statutory appeal, I have also filed a IA, your lordship. This is a conviction of only 3 years, your lordship, is entitled. Also, your lordship, till date, he is already in custody for 1 year, 9 months. That is also more than half the total sentence. So as per section 379 BNS says, and or 436 of the earlier CRPC, is more than half he is entitled to bail and.
It is for 3 years. Why is he not on?
No, actually, what has happened, he was in bail, but he was supposed to file an application, but there was a delay in this matter, so he was arrested. So otherwise, that is why he was in custody for 1 year, 9 months.
IA number.
IA is, your lordship, 138. He was actually, your lordship, suffering for a long time, your lordship, hepatitis, and that is why there was some delay in coming before this honorable court.
5 or
26. That was registered. The POCSO case number 1. POCSO case number 2019.
time?
1 year, 9 months.
trial court.
Admitted, your lordship.
There is private respondent.
Because of the, but that is the reason there was a delay, your lordship.
Okay. Speed put.
Obliged you.
Appeal against acquittal. In that case, we have filed a leave petition. The leave petition, there is a mistakes. The section 419, subsection 4 of, it should have been BNSS, not CRPC.
Original cases of which year?
It is of
CRPC or BNS era?
lordship.
Original
Coming
cases
to
of CRPC era or BNSS era?
Originally, it was CRPC era.
Then further proceedings will be under which provision? Etc.
The problem is that there are two findings of this honorable court. In one case, it is said that leave is not necessary. In that case, it comes to automatically register as a criminal appeal, a criminal decision. In other case, it's held that it will go to appropriate forum to district judge. Because that in that case, the findings appeal period is now 330 days. Case of appeal to the High Court, it is 390 days. We have two judgment of this honorable court. Different findings.
Against conviction, isn't it?
Lordship, no, appeal against acquittal.
Against acquittal.
Acquittal.
Okay.
Lordship.
So if it is assuming it is under CRPC,
Lordship.
assuming
Lordship.
that the proviso to 372,
Lordship.
it will go to district judge, session judge.
In case leave is not required.
That case leave is not required.
That is why I am still in under. I am also not this one not clear about that.
Oh, let us go to the question of leave later on. First of
Lordship.
all, question is where, in which forum will it lie?
In that case, district judge.
This case, and now Other case says,
Other case says it will be registered as a criminal appeal before the Honorable High Court. A case of appeal by the victim, it is not the case, it is the complainant case. Fine. In case of victim, it is 413. In case of
these two judgments are not in disagreement, but in the second judgment,
lordship,
there was a direction to register the appeal here itself.
lordship,
So perhaps otherwise it would have lied with the
under 413, appeal by the victim, for the district judge, or 419, appeal by the complainant, for the High Court.
Advisor clearly says that such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction.
Lordship,
So if had it been a case of conviction by the
Lordship.
CJM,
lordship,
appeal would have lied
the
before
district
the
judge, before the
session judge.
lordship,
In this case also,
Ah.
it is an appeal by the victim
lordship. It would have been district judge.
in district judge.
Here it will, exactly here is that case, it will be registered as a criminal appeal before the Honorable High Court now.
Acquittal was by CJM. Go to district judge as per this judgment.
That case, I have actually, my already limitation period is long back over. It is only 1 month. Here I am more than 3 months plus. So in that case, I may be protected under section 14 of the Limitation Act. Lordship, liberty to file before this district judge under section 14 of the Limitation Act. That liberty, that limitation period,
That a question to be decided by this court or before that court. There you were to plead that you were pursuing mistakenly pursuing a case
that
before
is
a
observation
wrong
is given,
forum.
observation is given by the Honorable Court. It will be easy for me, otherwise it will be difficult for me.
Counsel for the and
Party manager.
Complainant,
well as victim.
exactly.
Trial court on conclusion of criminal LP. Close. Dated 5.370 RPC provides us against the side. Appeal under ISO to section 370. Is before the in criminal LP. 5, the
Very kind of.
I'm being a
made figure. Well, the question is, my lord, no doubt, if the check is issued, my lord, presumption has to be that, my lord, that there is a legally enforceable debt, your lordship. The present case, your lordship will see page 30. For issuing check, my lord, we have entered into an agreement. The complainant, my lord, page 30, my lord, Annex A. And my lord may kindly come to first clause 1, that the second party,
get to that page first before you continue.
page 13,
1-3, okay.
1-3, my lord.
Yes.
This is the agreement, and the agreement was reduced. That will see, my lord, clause 1, your lordship, page 14.
You are a party in this agreement.
My lord, we have entered into an
First
agreement.
party or second party?
I am, my lord, second party, my lord.
Can move his.
My lord. Rajesh Kumar Moore, I am second party, my lord. So the issue was, my lord, for my lord, my lord,
Which part of this agreement do you want to refer to?
my lord, first your lordship will see clause number 1, serial number 1, my lord. Now
Yes.
may I read, your lordship? The second party awarded with the work order on 26/7/2023 from the Department of State Level Advisory Committee for Students and Youth Welfare, Assam, for work namely preparation of video advertisement for the duration of 1.5 minutes and 30 minutes with sanctioned budget of rupees 13,50,000. My lord, accordingly, my lord, video clip was prepared for 1.5 minute, and 1.5 minute was subsequently, my lord, increased by the authorities. $1.5. And my lord, so accordingly, bill was submitted by the petitioner before the authority. Since the payment has not been made, my lord, so 30-minute video was not given. Since the earlier video clipping was given and bill was submitted before the authority of 18,58,000 that I will place, my lord. So second was not given since they have not made the payment. Thereafter, my lord, as per the agreement, there was profit ratio that 50%, 60%, 40%, my lord, in that part also. That you also will see para 8, as per the agreement, we have issued post-dated checks that the second party shall provide equal amount of post-dated checks to the first party, which he will invest in his project. That the second party shall hand over the said videos after completing in all respect to the concerned department within 40. That was done so far as 1.5 minute is concerned. That the second party shall return the invested amount to the first party. My lord, first party has invested 8,50,000, and there was an agreement that we will share profit, and invested amount is liable to be refunded along with profit. Well, this is very important. As per profit sharing ratio within the next 60 days, which is count for after completion of 45 days. I'm pausing for a moment, your lord. So as per agreement, my lord, I am liable to pay profit sharing as well as the amount which he has invested. So, my lord, when the cause of action will arise, if I get the money from the department and I have not given him, then in that case, I can say that yes, the check, post-dated check, which has been issued, now it becomes, my lord, legally enforceable debt. But without receiving the amount, my lord, if the first party, my lord, deposit the same and it dishonored, it cannot be said, my lord, under section 138 that there is a legally enforceable debt. learned trial court, your lordship, has not taken into consideration this present agreement, because entire this case is based on this agreement. If there is a violation, my lord, this is a good case. I am liable to pay. If I have received the payment from department, and my lord, these are the bills which I have submitted before the authority. 18 lakhs, so the amount which he has invested and profit, it will cover, my lord, from, so far as this amount is concerned. एक ही copy. $18 lakh, 18 lakh 50,000. So my learned friend has invested 8 lakh 50,000.
Your contention is that
My
the
lord,
liability arises only upon receipt of the.
if I receive, I am not making payment, then my liability is there. My lord. This is small. This is learned trial court has not considered that aspect.
Where is the trial court's order?
My lord. Complaint, my lord, page 18, and order, your lordship will find at page 28. Case record 28, my lord. May I read, your lordship? Case record is received so and so. The complaint, namely so and so, he has filed the initial disciplinary evidence on affidavit so and so. I have gone through the complaint petition and the evidence on affidavit, and also examined the documents submitted. Upon consideration, it is found that prima facie there is a sufficient ground for proceeding according to so and so. There is not a single whisper, my lord.
Can there be a whisper? Go by the complainant's documents.
Document,
But
there
to
is a
appear and
mention.
show it there.
Yes, there was there, my lord. The complaint was there before learned trial court.
Complainant was there. Where were you?
Hello, at that time, without issuing notice, how can I,
Will go with the agreement.
my lord?
But to go and appear there, show the agreement, then it is to be decided.
I am challenging.
The argument that you are making before this court, that
My-
is to be decided by the trial court. You have just before anything happens, you
My
have
lord,
straight
so far
away
as
run
this
to the high
taking,
court.
taking cognizance, because taking cognizance might directly hit Article 21, my lord. Unless until learned trial court will not go into simply writing what documents, nothing, my lord, there is not.
The trial court required to consider your defense at the time of taking.
I'm not saying
cognizance.
so. But if the entire case is based on that agreement and there is no violation because I have not received payment, then the question of taking cognizance will not arise. In the complaint, they have mentioned about, my lord, this complaint, that agreement, my lord. Page 20. They have annexed as annexure 1. Criminal cases, my lord.
If they are relying on that agreement, then you are out anyway, because according to their interpretation, the liability has already arisen.
But as per agreement, it does not.
No,
Because
that
they
is
are,
your argument,
but-
that is their
my
argument.
lord, that's why we are
That is
before
what
your-
is to be decided by the learned court below.
in the
before you come
agreement, it
here.
is written that they.
Why would we interfere at this stage and say decide the issue beforehand?
Your lordship may say that, your lordship may set aside the cognizance order, remand back the matter, and direct learned trial court to decide the matter and taking into consideration the that agreement
At the stage
before taking
for your
cognizance.
appearance.
Material is before trial court, my lord.
Case of NIAC, my lord, not disputed with regard to taking of 8,50,000 by bank transfer. Now, my lord, will kindly come to paragraph 2 of this agreement they are relying in. So the first party desires to invest in his project with the second party, and second party also agreed the same. Now the first party agreed to invest an amount of rupees 8 lakh in 3 defined installments. Now they are admitting with regard to this that I have paid that amount. Now, my lord, will kindly come to their case. The second party shall provide all the details of expenses to the first party relating to this project. nothing been given. That the name of the both the party shall be reflected in the document in production column. I'm not on that. Next, the second party shall provide equal amount of post-dated checks. It is not post-dated checks. Para 6, 8, my lord. The second party means the petitioner before your lordship shall provide equal amount of post-dated checks to the first party which he will invest in his project. So these checks were never been given. This is of agreement of date is very important, my lord will kindly see. 18th day of August 2023. Now these post-dated checks were never given. Now next paragraph, 9, clause 9, that the second party shall hand over the said videos after completion in all respect to the concerned department within 45 days date of signing of this MOU. The next is very important. 10, that the second party shall return the invested amount to the first party along with the profit as per profit sharing ratio within the next 60 days, which is count from after completion of first 40 days. So payment has to be made within 60 days. Now, my lord, in view of this clause, they have issued a post-dated checks, my lord, not post-dated check. Thereafter, they have issued a check which is dated 4/3/2025. Check is dated 4/3/25. One single check, 8,50,000, my lord, not 3 checks. Against this particular existing liability, they have issued these checks. And this is in his personal name with regard to the respondent, my lord. And where is the case with regard to interpretation of the provision of this particular agreement? I rely on a recent judgment, my lord. This is very important. Now here what it happens, my lord, a builder entered into an agreement with another party, my lord, to agreement to sell. Now this flat could never been given. So the builder entered into an agreement and thereafter, my lord, gave post-dated checks. Now on that very basis, when it was presented, it got dishonored, my lord, and he after complying with the mandatory provisions under the NI Act, giving notice and everything, they were mum. After filing of the case, they go for quashing. The matter went to the Supreme Court. Supreme Court said as it is, my lord, here in this case, notice, my lord, has been issued to them under NI Act, my lord. No cause of action arises unless I issue notice. Notice there is no reply with regard to this. I file my case, there is no reply. These are nothing but afterthought to evade and buy time from the Honorable Court. So here in this case, my lord, paragraph 26, 27, my lord will kindly note that 39, 42 and 43 is very important. 26, 27, 39, 42 and 43. My lord, I am reading, my lord, paragraph 39, my lord. 39, 42 and 43, my lord. Paragraph 39, my lord, if your lordship appreciates it, my lord, a Supreme Court earlier judgment has been discussed. On the reading of the provision 138 of the NI, it is clear that the ingredients which are to be satisfied for making out a case under the provisions are 1, 2, 3, and 4, my lord. That's the contents of the NI Act itself, my lord, 4 and 5. And 42, my lord, will kindly appreciate. Whoever, we are of the view that the burden of proving whether there exists any debt or liability is something which must be discharged in a trial, sir. A bare perusal of 139 of NI would indicate that once a check is issued in discharge of liability at dishonor, a presumption of liability in favor of the complainant arise. The accused person is then required to rebut the presumption by raising facts that either there was no debt or liability when a check was drawn, or the check was not drawn in discharge of liability, or notice was not served in time. In this regard, we rely on so and so judgment. In 43, my lord, the statutory presumption attached to the issuance of a check being one made in discharge of legal enforceable debt or liability is required to be accorded due weight. Therefore, in circumstances where the accused approaches the court seeking quashing of a proceeding, even before the commencement of trial, the court must exercise circumspection and refrain from preferring shifting the prosecution at the threshold, particularly by overlooking the legal presumption that overrides in favor of the complainant. That's all, my lord. And if the agreement need to look into, payment has to be made within 60 days. 23 agreement, my lord. 25, he issued a post-dated checks. No earlier checks was given to us. So in discharge of liability, he has given it, whether he gets it or not. The ultimate is 60 days. That is the part of the agreement. If he gets payment, doesn't matter to me. Debt is admitted debt. Once debt is admitted, my lord, what is the scope of interpretation, my lord?
After completion, my lord, can be said to be.
Is there any clause in your agreement that only after you receive the bills, this liability would
There is
arise?
no
They are
clause.
saying- There is not specific, but they are saying in the agreement that with profit, when I will give profit, my lord, if I receive, in that case only.
How? The profit is included in your bill. You
That's why the payment, unless until payment
have
has not
calculated the profit and that way you have submitted the bill.
bill and we have not received payment.
There is no clause in the agreement that only when you receive
But
payment you
it
will
is
get it.
written, my lord, after completion of first 45 days.
That if that condition was there, he may not have agreed to it.
Absolutely. And my lord, this is not for profit. This is only the principal amount. Profit I have to get. This, he returned it only for profit 8,50,000, which I have invested
I
within
am
60
talking
days.
about his bill. Talking about
Yes,
his bill.
yes. My lord, that includes the profit. My lord, he has given the principal amount. Profit he will give me later on. This is for the principal amount.
That's why it is written, my lord, first party along with profit. If profit element is not there
You have calculated the why it is not there. It is there,
in the bill,
not in your pocket. That's a different thing.
True.
But you
so
have calculated
from
the
where I will
profit.
give, since the money was not with me, that's why I have taken.
Should have included that as clause in the agreement.
That is true, my lord.
That is true.
part-
You're out.
that agreement is clause is not there specifically. But my lord, if we read entire agreement, this is the intent of agreement that if I receive money, only on that case, my lord, if I am not giving him, then the question of my lord, and regarding what my learned senior
What was
friend,
your submission regard by him? What was that is not included here?
No, my lord, this is an agreement wherein, my
You
lord,
referred to some check of the 8 lakh something paid by.
yes, 8,50,000 is the principal amount I have invested, not the profit person.
No,
He
no,
is
no, it
returning
is
me
on
the
record.
principal amount.
Record here.
My lord, they have not annexed herein, but we have, my lord, the copies of the checks, my lord. Yes, these are exhibits and part of the record, my lord. And in the lower court record, they ought to have annexed it, my lord. And nothing to dispute with regard. Only the principal amount, my lord.
but in the agreement it is written post-dated checks, my lord.
Checks, number of checks.
Number checks.
But you have not given. You have given in 2025 with regard to the principal amount.
Sir, it is also disputed.
All right.
My deeply aware.
Take my, there is no delay petition. Notice can be issued because leave has been already granted and it is. I also checked in the my lord record, my lord, in the website, my lord, there is also nothing.
There is no delay.
There is no.
Okay, no
Yes.
difficulty.
It is makes a confusion in the order, my lord. This may be issued.
Yes, 49. 9. But Mr.
sole respondent.
Take steps.
Lordship,
Steps by
steps by 5 days,
what manner?
by registered post or speed post mail. Speed post mail. Obliged.
May I please, Lord? My lord, a case, my lord, where this petitioner before your lordship filed initially one complaint case, my lord. My lord, after my lord filing the complaint and by passing order.
Into the case writing, and apart from that, the service is service not
Respondent number 2 is not. Taken steps.
Perhaps so far I, my lord, I am not wrong, my lord, it was provided to take by. No, it was private respondent is OC.
Here also not received, it seems.
in search, then we can
In search.
Officer in general. Therefore, my lord, it was earlier occasion, my lord.
Third learned counsel for the
Turmoil.
that is admitted for.
Kindly, my lord, interim order. Deployable.
may I please, your lordships. Appeal against acquittal, lordship, leave granted. Admitted issue notice.
Implement order, so but this NIA
Complainant.
case,
I am the complainant. Other side is opposite accused, lordship. She was acquitted. Special leave was granted and disposed on 13/2020.
right to appeal before the judge itself.
Yes, lordship, kindly 490, 419 4 lordships, BNN. 419 of the BNNS lordships. Both lordship, there is no limit, both even session, even both the high court. 19 may kindly be looking. Yes,
Leave has already been granted.
Yes, Lordship.
Here's that both options are available.
Both options are available, Lordship.
Has already been granted. Again on.
There may be call for. Use.
Yes, please, Lordship. This case is, and if Peru's Milo's last order dated 6/2/2026, might was wrongly listed today, might.
If to appeal.
And in the last order, might the order
Last
dated
order in the IA. In the IA.
in a criminal LP, might 27, might criminal leave application, might leave petition. And might yes, my lord.
The instant.
Deeply present.
Lordship, can the matter be taken after a while?
The regular bail application, Lordship. FIR at page 14, Lordship. Lordship, here is allegation that 38 number of potent phosphate and in syrup was recovered from the
This page FIR
14, Lordship.
14.
Yes, Lordship. Immediately, Lordship, under the weight of the present petitioner, Lordship. 38 number of potent phosphate. Lordship.
Yes, Lordship, TCR received, Lordship.
Oh, Lordship, kindly see, Lordship, I'm only basic ground, Lordship, kindly page, Lordship, that is 29, Lordship. It is a 48 notice, Lordship. There is a blank, Lordship, totally, there is no ground of arrest mentioned, Lordship. So it's well settled, Lordship. It cannot be written further, Lordship. Fine, Lordship. Lordship of the past and elaborate order, I have 48 front. And in English language also, Lordship, but the wife of the petitioner, their signatures are in Assamese language, Lordship.
Yes, PP. No.
Arrest is of 14/7/25. He is prior to Mihir Ranjan Shah. That case lordship will go by the record lordship whether he is demonstrated and she then that I have gone through because lordship if his arrest is after Mihir Ranjan Shah, then I have nothing to say.
Prior to Mihir, our division bench judgment, Lordship, our High Court division bench judgment is there.
On the apex court judgment also.
Prior to, that is why on that particular time, Lordship.
Record to be registered. Not received. Chairman, not received. Well, days.
356 days, my lord.
They're not received.
In this case, Lordship, already dispose of matter is tagged, Lordship, probably TCR is there along with. That dispose of matter is tagged here, Lordship. On dispose of BA number 2536 of 25, Lordship. Putting that.
Case.
Yeah, Lordship, FIU, Lordship will find page 13. Lordship.
P0.
The 1-3, Lordship. Investigation, Lordship, police subject charge sheet, Lordship, and he is in custody for 11 months, 22 days, almost 1 year, Lordship. And he earlier approached before this honorable court, and your Lordship was pleased to dispose of that bail application at page 53, Lordship. Page 53, Lordship, just one thing I'm pointing out, at page 54, paragraph 5, your Lordship observed that the case has already been charge sheeted and the case has also been committed. And as per my instruction, Lordship, till date, that committal process was not complete, Lordship. It's still in appearance stage, Lordship. No one has appeared, and one person has not appeared, Lordship. Therefore, he is still in custody, Lordship. There is no chance of early disposal of the case in view of the fact that there are 17 numbers of witnesses in the charge sheet, Lordship. Already he is almost 1 year in custody. Other persons were arrested and subsequently they got bail, and Lordship, some of them are regularly appearing, Lordship. Case 66 is one of the accused, co-accused order, Lordship. Dear Lordship, with him, Lordship, the present petitioner was having allegations, Lordship. Against him, he was granted default bail. Case 66, your Lordship will get. In the present case, police initially filed one charge sheet and subsequently filed another supplementary charge sheet. But in spite of that, they have not filed any charge sheet against the other accused who got default bail, Lordship. Not on same footing, Lordship, but he is already on bail. That part, Lordship, may consider, Lordship. Filing of charge sheet, they have not brought any new material against that. Already 1 year in custody, Lordship. The allegations are against DNS, Lordship. Restrictions against that, Lordship. He already in custody for about 1 year, Lordship. At a committal stage, Lordship. Considering these aspects, Lordship.
Yes. My lord, trial is in very nascent stage, my lord. Second, my lord, that have appearance. Seated accused, my lord.
He will face the trial. He is local. 1 year in custody in the charge sheet, Lordship.
One accused is yet to be apprehended. Because of that, it has not been committed as. Same.
Obliged, Lordship.
Lordship file name.
None. Very weak.
Rightly correct. And he is not named accused in that case, my lord. Prior's, my lord, allegation is not also so serious. Since last, my lord, 10, 11 occasion.
No, my lord, it is charge sheeted, my lord. No, my lord, 39 of 25, my lord. 9, 11, 20. 29, 11. Yes, my lord, 39 stroke 25, my lord. Dated 29, 11, 25.
Obliged. Put it here.
Earlier rejected.
Based on FSL report.
In this case, my lord, lordship earlier rejected this case, my lord, we have to update the case study, my lord. Because, my lord, it is the latest, my lord, it is 31, 10, 25, my lord. And that, my lord, report also not here. Allow us to update.
First date of entry there.
There is in, my lord, it is the, my lord, 31, 31, 10, 25.
Pre-murder order was not.
Can break the CD.
Obliged.
My lord, protected to petition, my lord. All the petitioners from the same family, my lord. Case that was called for.
My lord, is there a receive, my lord, in, my lord, is there a receive in case, PS case number, my lord, 283, my lord, and 284, my lord, charge sheeted.
Yes, my lord, on 12/11/2025, the informant's family that the paddy field of the Mylord
There
petition.
was an order for listing it before the appropriate bench something. Earlier,
Since Mylord,
not earlier rejected last, as far as I
no,
remember,
no,
last
my
time
lord.
this question was on top of the file, it says rejected accused.
No, my lord, it is not. This is a press case, my
There's a
lord.
noting by the registry here. Is the matter before me. Because same
be-
rejected
My
accused.
lord, might be for the arrested person, my lord. But I have not, my lord, filed. This is a press case, my lord. Since 29/1/2026, it is running in this case.
Kobindra Orali was arrested, my lord.
Kobindra and Mukut Bharale. Both were, my lord, already released, my
Where
lord.
is there?
Lord, his statement is here, my lord. After,
Oh, if they were granted bail by another court.
I don't know,
no,
my
my lord,
lord.
death order is not here, my lord.
By the court below, my lord. Already they have
The court
spent
below.
90 days, my lord, in custody, my lord. They were granted bail, my lord. Both of them, my lord.
Submitting something?
Yes, my lord. My lord, the prime accused is, my lord, as per the witness of the, my lord, eyewitness, my lord, Kobindra. But, my lord, present petitioners also help him. And, my lord, ultimately, my lord, one person died, my lord. And
They,
his postmortem report is also here, my lord.
both parties, my lord, receive injury, my lord.
That is true, my lord.
My
but
lord,
it's not-
Mukut Bharali and one Nirola Bharali, their mother, my lord. They both of them received severe head injury, my lord. And the petitioner number 2 has lost his fingers, left his fingers, my lord. And all were injured, and all of them were treated in the Gauhati Medical College Hospital, my lord. I have annexed all documents, my lord, medical documents.
My lord,
Petitioners,
My lord,
how many petitioners in this
petitioners,
application?
there
5.
are 5, my lord.
Orally, what is there against him?
yes, my lord. লগতে মদন, মুকুট, জিতু, ৰাতুল, প্ৰণৱেও এই কামত কবীন্দ্ৰ সহায় কৰিছে. Kobindra gave that blow to, my lord, that Ranjan Das. Ultimately, Ranjan Das died, my lord. And in that scuffle, my lord, these persons, my lord, the petitioners helped Kobindra. PM report also, my lord, not but injury are there, my lord, but not to see, because, my lord, that Pisara was sent, my lord, that is not here. This is the, my lord.
What parties receive injury, my lord? It is true, my lord. Does the informant's son died? It is also true, my lord. What party received injury, my lord? And the police has tactfully, my lord, submitted charge sheet in the second case, my lord.
In accused is Kobindra,
My lord.
granted default bail. Default bail.
Yes. Recently, my lord, few days back, my lord, he is released from jail.
There are some weapons in the hands of the petitioner.
Caddy from the Golab Bhorali.
Don't das, my
Don't
lord.
ask, my lord.
Succumb to injury, my lord.
Affair about Ranjan Das.
Golab Bharali, my lord, he received my head injury, severe head injury, my lord. Was arrested earlier, my lord,
Bhorali,
from the my lord,
Right.
my lord. They are the present petitioner side, my lord. They are pedi, my lord, that was cut by the, my lord, informant side. FIR was there, my lord.
affair of the present case is where?
My lord is, it is in my lord, page, my lord, 22, type page is 25, my lord.
weapons as a result of prisoner that the were sustained by as that took place with and in this regard here
At page 31, my lord. Second FIR.
12, 11 74 2 and Proc 3 so 5 BNS. The cases have been received.
Oh, no, my lord. My lord,
My
CPR, my lord, 283 received, my lord.
Present case.
Yes, my lord. At 284 is charge sheeted.
Sheet. The main accused had also helped main accused murder. Test wall. Other co-accused released on bail.
Who, my lord?
Another co-accused, namely
Namely, my lord, Mukut Bharali.
pending for final report of
My lord.
complete.
Arnachizam Amin Gaon. Yes, my lord. Deeply obliged, my lord.
Yes.
Regarding that part, Lordship. Definitely no one represented him, Lordship, in. Lordship.
Focus.
My lord, my one, that after getting interim, my lord, his statement I have not found in that. Maybe, my lord.
Appeared.
Kindly extend the interim, my lord, I will.
Appear again.
Yeah, please.
Obliged, Lord.
Date resolved also. My lords, in this matter, my lords, charge sheet has already been filed and the petitioner has completed 188 days. The FIR is at my lord page number 24.
That call for updated and up-to-date copy of this has been received. Development.
That till date, no PWs have like this, that the petitioner, my lord, was having an affair with the co-accused Afruza. And my lord, this deceased, my lord, he had somehow obtained some, my lord, sensitive photographs and videos of these two persons, my lord. And he was blackmailing them. Was not seeking any money, but he was demanding sexual favor this co-accused Afruza. And on this particular date, my lord, this Afruza invited both of them, my lord, to this place of occurrence, my lord. There some altercation happened, and in that altercation, my lord, this person died. That I'm not submitting off the record, it's in the record only from the statements of the accused. This thing is clearly mentioned that he was demanding sexual favor. So, my lord, even for the purpose of bail, my lord, even if we admit that this person had died, but my lord, it will not be a case of culpable homicide, but maybe homicide not amounting to murder. And other thing is that if your lordship will kindly see the 47 notice, that notice is in English, my lord, whereas, my lord, the petitioner had put his signature in vernacular, my lord, Assamese language, my lord. Perhaps, my lord, it was not explained, or it was not, the grounds were not communicated in a language understandable to the petitioner, my lord. That is one ground. And the next thing is that, my lord, the petitioner has completed 188 days, my lord. So he is ready to face trial, my lord.
Where is the FIR?
FIR is at page number 24.
Third lordship. Ground has been mentioned. Lordship. English lordship in ground of arrest lordship 47 notice. That is, he has signed in Assamese. In 48 notice, the person who has received that notice, he has signed in English. But also when person is arrested and he is in custody, who will engage the advocate? Who will engage secure his release lordship? That the person 48 who has received the notice 48, and he is aware about the ground of arrest lordship. Ground of arrest lordship in writing Assamese English. That part here probably may not come because lordship, the person who has received the 48 notice, he knows the English very well, and his signature itself says he knows very well aware.
Not related, my lord. He is some, my lord, member of some and whether, my lord, we had nominated this particular person, that is not mentioned in the 14th. Whether it was nominated or whether the police nominated, my lord, nothing is there. Even otherwise, regarding the technicalities, my lord, lordship will kindly the 180 statement, the entire actual fact is there.
I don't know. Statements lordship itself, why how he has been also injured.
But whether
At this stage also no
or
okay.
based on their own confession.
Yes, that's why I'm relying on that.
There's only a scene discovery was already made. Learned counsel for the pit. of arrest.
Date of arrest, my lord, 18/12. 16/9, my lord. 16/9/2025.
Spare tick mark.
Yes, sir. কালিয়ে গম পাম আৰু কি হ'ল।
Suicidal.
On, my lord. Committed, my lord, pending for
A charge has been framed. shall not try to intimidate.
File your blessing.
Lordship. Charge has been submitted, Lordship, under section 331 and 64 of the Learned Trial Code below has taken cognizance under this section. Lordship will find the cognizance order at page 24. Common from the trial code below, Lordship. However, since the sections involved in this session tribal sections, Lordship, so the present petitioner is under the apprehension that upon his appearance before the trial court below, learned trial court below, he arrested and sent to judicial custody. The learned trial court below does not have the jurisdiction to grant present petition before you.
FIR.
FIR is at page 11, Lordship, the translated copy.
Contrary TCR, my lord, there are, my lord, the in one it says it stated the petitioner. This he was my lord. Appear and
We have supported the version of the
appear and cooperate with the trial, Lordship.
yeah, nobody is preventing you, but
Lordship may kindly see page 21, Lordship, that is well, opinion is there, Lordship, on the last para, Lordship. For neck region and USP pelvic organs reveal were detected on vaginal
report says a married woman.
Married woman, my lord, and even without them,
Then there are injuries. Support the fact. Well, we can only like we can pass an order that you will
trial court below has
the other option is that we pass. We've had learned counsel for the petitioner and to the
problem.
FIR is at page, my lord, 18, Ernakulam. CD has been called, it is today is the third occasion, my lord. CD has not come.
date. Not
the
received.
notice, the
Informant is appeared. My lord, the prime
Report.
accused has been granted default bail by this honorable court. On certified order dated 26/11, page 30.
this is AB, my lord.
Alleged incidence is of 21/6/25. My lord, 30th. Next Monday, my lord.
Obliged.
36, 37, connect. 35, 36.
I received awaited receipt. Steps taken on only, Lord.
Time also I have taken a step. Time I have taken steps.
amicus maybe.
So and so.
It shall be retained also.
Written, can be written.
It's taken on 18 thrillers.
As per order 7/126.
That is what you have entered appearance. We'll
Yes, Lordship.
it again for admission.
May I please, your lordship? Lordship, steps were taken and I have checked with the office note that no has been received. Steps were taken, your lordship, through the concern. My lord, the interim stay may be extended.
Till next date of leave.
Obliged, your lordship.
My lord, we have taken fresh step, but
Till the next date.
Be obliged.
Office note dated 19. Service report awaited, lordship. We have
Submitted that steps.
His lordship, parental and ed are able to take steps. Urgency, lordship, was rest. Uh,
Number two,
yes.
steps by dusty service then. Done
Lord,
to concerned police station.
her address is not raised.
It is your lordship. There is an IA. Not in this IA, lordship, we are praying for a recon on 2024. Lordship, what has happened in this matter, Lord? Directing by this on the amount of 1 lakh and the monthly maintenance of 10 time being. 1,000 were deposited. Lordship may have the IM, Lordship. Lordship, at page number 9, Lordships. Was the order, Lordship, wherein the IA was maintenance amount of rupees 10,000 and 1 lakh was to be deposited. The relevant portion is page 11, Lordships. Page number.
Entered appearance already.
Entered appearance, we have made a payment of 1 lakh and 1,30,000. That was 10,000 per month. Meanwhile, by Lordship's order dated 12/11/2025, Lordships. Lordship, this order was vacated for non-compliance of that 10,000, Lordships. Now we have updated the entire thing, Lordships.
Learned counsel for the
Admission. Later on, Lordship. I'm so obliged.
In this case, my lord, the petitioner, my lord, is reportedly, lordship, expired, lordship, but the by last order, lordship, I was, my lord, directed to submit the death certificate, lordship. But the death certificate has not been produced, my lord. I have been, my lord, repeatedly calling the, my lord, deponent in this case, lordship. My lord, the IO, the police station, my lord, OC of, my lord, OC of the Valpara police station may be directed to, my lord, to submit the status of the, my lord, petitioner.
come to you.
What my name is.
He's not coming.
No, no,
The
as
police
far-
will run after him, Lordship.
My lord, his brother stated that, informed me that he has expired, lordship. He, long before, my lord, during Corona, my lord, he expired, lordship. But that certificate has not been produced. I have been repeated, I have informed him, lordship.
So many
No,
work
my
that
lord,
only because of that now searching the persons whether he's alive or not, that through their duty did.
Sir, I mean learned counsel.
M.H. Ahmed, lordship. M.H. Ahmed.
H. Ahmed. Earlier,
My junior, my colleague appeared, lordship. That's what.
of the get any response from the family members of the
Yes,
petitioner?
Lordship.
Accordingly.